Hi everyone, I am Diesel Pilibarios and I'm going to discuss the Bureau of Labor Relations. So the Bureau of Labor Relations covers all important aspects of labor relation. They set the environment for a healthy relationship by making both employer and employee aware of their rights and obligations. They also promote collective negotiation and provides mechanism to fix strained relationship through adjudication. And most of all, they foster an environment where employers and employees can reach a compromise regarding their issues and contribute in policy making. So a brief history of how labor relation was established. So the Bureau of Labor Relations was established on January 16, 1957 in the pursuant Executive Order number 213 and the Organization Plan 28. It took over the Conciliation Service and Register of Labor Organization created under Republic Act 875 and served as planning, policy making, consultative, and advisory body in promotion and maintenance of industrial peace. The Bureau of Labor Relations continues its mandate to develop policies, programs, projects, and guidelines and standards relative to labor management. So, functions of Bureau of Labor Relations. So, the functions of Bureau of Labor Relations is to set policy, standards, and procedures on the registration and supervision of legitimate labor union activities, including denial, cancellation, and revocation of labor union permits. Also, Bureau of Labor Relations provides orientation to workers on their rights and privileges under existing law and regulation and develop schemes and projects for the improvement of the standard of living of workers and their family. So, mandates or official orders of Bureau of Labor Relations. So, first is National Registry of Unions and CBA. Next is formulates regulatory and development policies, standard, guidelines, and programs promoting the rights to organization, including collective bargaining and improvement of the income of workers under organization. Next is lead agencies, workers, and employers' education. Educate inter and intra-union disputes. Next is promotes bipartisan and tripartisan. And lastly, formulation and implementation of programs that strengthen the unions to achieve industrial peace. That's all. Thank you.
Good day, everyone. I am Jewel Garcia and I'm going to discuss the National Conciliation and Mediation Board. Executive Order Number 126 in January 31, 1987 created the National Conciliation and Mediation Board or NCMB as an agency attached to the Department of Labor and Employment or DOLE. The NCMB absorbed the conciliation and mediation and labor management functions of the Bureau of Labor Relations and its counterparts in the regional offices of the department. The National Conciliation and Mediation Board was created to formulate policies, develop plans and programs, and set standards and procedures relative to the promotion of conciliation and mediation of labor disputes, administration of voluntary arbitration program, and the promotion of other cooperative, non-adversarial, and voluntary modes of labor dispute settlement. Through its labor management corporation programs, the National Conciliation and Mediation Board facilitates the setting up of functional mechanism for information sharing, effective consultation, and group problem solving, whereby labor and management can jointly and voluntarily discuss matters covered by their collective agreements. In so doing, the board renders advisory and counseling services on various aspects of labor management relations. Conciliation and mediation is a mode of dispute settlement that brings together two disputing parties to negotiate and settle their differences. to differentiate conciliation is a mild form of intervention by a neutral third party, and the conciliator and mediator, relying on his persuasive expertise, who takes an active role in assisting parties by trying to keep disputants talking, facilitating other procedural niceties, carrying messages back and forth between the parties, and keep things forward looking in the situation. The DOLE, through the National Conciliation and Mediation Board, promotes conciliation and mediation as the preferred mode of resolution to unfair labor practices and bargaining deadlock issues, to prevent notice and strikes or lockout, and preventive mediation cases from maturing into actual work stoppages.
Good day everyone, I'm Willoughby Pilihan and I will going to report about the Dolly Regional Director and Secretary. In Coronadal City, the Department of Labor and Employment 12 changed its leadership with the entrance of Raimundo G. Agravante as its new Regional Director effective on June 16, 2020. This after former Regional Director Cecilio B. Cano Seso III retired from the service and passed responsibility to the new director. R.D. Agravante hails from Libungan, Cotabato Province, a homegrown leader of the Soxargen. He finished his Bachelor of Science in Agriculture at the University of Southern Mindanao in Cabacan, Cotabato, while his Bachelor of Laws and Notre Dame, the University Cotabato City. R.D. Ray, as he is fondly called, is also a graduate of Master of Arts in Development Studies from the Institute of Social Studies at the Netherlands. Prior to his assignment in Dolly 7, he served Dolly in Region 3 for NCR 4A and as Regional Director of Dolly 9 from 2014 to 15 of June 2020. The current Secretary of Dolly is Sylvester Bello III. He is born in June 23, 1944. Bello is a Filipino businessman and lawyer from Isabela. He is the current Secretary of the Philippines Department of Labor and Employment and concurrently Presidential Advisor on the peace process who assumed office on June 30, 2016. Bello was appointed by President Rodrigo Duterte to replace Rosalinda Baldos in the secretaryship. Bello was a former Justice Secretary, Solicitor General, and representative of One BAP party list during the 16th Congress of the Philippines.
Good day, I am Tom Galan. I will discuss prescribing guidelines in the prescription of actions and the suspension of reglementary periods to file pleadings, motion, and other documents. In the interest of the service and pursuant to Administrative Order Number 30, Series of 2020, of the Office of the President, directing all government officers to formulate and issue guidelines on the interruption of periods for filing documents and cancellation of proceedings. The following guidelines shall be observed in all programs, projects, and proceedings before the regional offices, bureaus, and the Office of the Secretary. So for Section 1 is prescriptive periods. The prescriptive periods for the commencement of actions, claims, petitions, and complaints and other proceedings before the regional offices, bureaus, and the Office of the Secretary of the Department of Labor and Employment shall be interrupted reckoned from 16th of March 2020 and shall begin to run when the enhanced community quarantine or general community quarantine is lifted. For Section 2 is certificate of registration. So submission or renewal of documents, also for registration of certification, are also suspended. Section 3 is alien employment permit. So for AEP the application for new or renewal of alien employment permit can be filed within 45 working days after the lifting of ECQ or GCQ. This is without imposition of penalty. And also for Section 4, private employment agencies permits can only be filed within 45 working days after the lifting of the ECQ and GCQ. So for Section 5 is petitions for certification election, inter and intra-union cases. Cases relative to alien employment permits, labor standard cases with finality and child labor cases. The filing of pleadings, motions, and other papers relative to what I have mentioned cases is suspended for the duration of the community quarantine. Likewise, rendition of orders, judgment, and resolutions are also suspended. So from Section 6 to 10, which includes the routine inspection, complaint inspection, and occupational safety and health investigation, and service of writs of execution, permit to operate mechanical equipment of certificate of electrical wiring installation, then lastly, single entry approach or SENA. So any filing of requests, submission of documents are also suspended. For Section 11, proceedings before the Office of the Secretary. First is conduct of hearings and conferences. Proceedings on administrative assumption of jurisdiction and voluntary arbitration are also deemed suspended for the duration of ECQ. As such, all pleadings, motions, and other submissions made by the parties which are pending before it shall be acted upon the community quarantine has been lifted. B, and still under Section 11, B, it appeals to Secretary of Labor Employment or SOLE. 1. If the period to file appeals or petition for review from the orders, resolutions, decisions of the regional directors or Bureau of Directors, POEA falls under the ECQ period. So the period for filing the same shall be suspended and shall commence to run 15 days after the lifting of ECQ. 2 is if the period to file a motion for reconsideration from the orders, resolutions, decisions of the SOLE on the appealed cases falls within the period when the ECQ is subsisting, the said period is deemed suspended and the movant may file the intended motion for reconsideration within 15 days after the lifting of the ECQ. So last is Section 12. Separate guidelines to be issued by DOLE, bureaus, and attached agencies. The bureaus and attached agencies of the DOLE shall issue pertinent guidelines to implement their respective procedures and processes in compliance with AO 30 series of 2020, which is the prescriptions of actions. Thank you. That would be all.